welcoming you all in today's third session of Manikchand Pahade Law College CT Preparation 15 Days webinar. Before I invite our today's guest, there are some instructions to all our attendees. Please kindly mute your microphones and cameras so that we will not get any disturbance during the session. This session is also streaming live on YouTube channel. After this session, we will have a question and answer round. If you have any questions, you can put in chat box of this app and on YouTube also. They will be answered by our today's resource person. Also, if you are facing any network issue, you can join on our YouTube live. Today, we all have privilege that Professor Morey sir are with us today. He will be dealing with Indian Constitution topic. प्रोफेसर श्रीकिशन निवृत्ति मोरे, सहयोगी प्राध्यापक तथा उपप्राचार्य मानिकचंद पहाड़े विधि महाविद्यालय औरंगाबाद, जन्म 15 ऑगस्ट 1973, बीएससी ही पदवी मिलिंद विज्ञान महाविद्यालय औरंगाबाद येथून प्रथम श्रेणीत पूर्ण, संवैधानिक कायदा हा विषय घेऊन LLM पूर्ण, महात्मा फुले व डॉक्टर बाबासाहेब आंबेडकर यांचे विचार या विषयात MA, LLB व MA परीक्षेत डॉक्टर बाबासाहेब आंबेडकर मराठवाडा विद्यापीठ औरंगाबाद मधून मेरिट मध्ये उत्तीर्ण, 9 जानेवारी 2002 पासून आजपर्यंत मराठवाड्यातील पहिले विधी महाविद्यालय माणिकचंद पहाडे विधी महाविद्यालय औरंगाबाद येथे कायदा विषयाचे अध्यापन चालू आहे. भारतीय संविधानातील तत्वज्ञान व डॉक्टर बाबासाहेब आंबेडकर यांचे विचार व प्रसार कार्य, लिखाण, शैक्षणिक व सामाजिक उपक्रमातून चालू आहे. राष्ट्रीय व आंतरराष्ट्रीय परिषदा, कार्यशाळा व चर्चासत्रात सहभाग व शोध निबंधांचे वाचन यासाठी त्यांना अनेक पुरस्कारही मिळाले आहेत. महाकवी वामनदादा कर्डक,
सर माधुरी कनेक्टिव्हिटी मध्ये नाहीये. मोरे सर पुनश्च एकदा स्वागत आहे. हा तुम्ही चालू करा.
Thank you, Madhuri and Dr. Vassar. Also is with Dr. Amol Vansar, who is coordinator of this session and webinar. I am thankful to the honorable management of our Marathwada Legal and General Education Society for organizing this Law CET preparation 15 days free webinar for all the participants over the Maharashtra who are the aspirant of Law CET. I am also here for welcoming all the participants. Though I am introduced here as a guest, I am not a guest. I am the host of this webinar, one of the organizers. So I shall welcome you all the participants who are attending this webinar from different parts of the Maharashtra, and they are from the metropolitan cities as well as they are from the remote areas, and there may be the different challenges for them to attend this webinar, but even then they have shown the active participation and they are attending this webinar. At the outset itself, I will give them all the best for their CET examination. The topic which is assigned to me is the Constitution of India. Dear student, in this lecture, I am taking you on only two topics, two issues or two modules. And these are, number first, what is Constitution? And secondly, what are the salient features of the Indian Constitution? And again, I must tell you that the important topic of the fundamental rights and directive principles of the state policy and the fundamental duties and other issues will be discussed by the other resource person on the Constitution of India. We have actually arranged 3 lectures on the Constitution of India, and this is first, second lecture will be by Advocate Chaitanya Dharurkar, and third lecture will be delivered by Professor Abhay Jadhav of our college. And they will take care of the remaining portion of the present lecture of the Constitution of India. Also, I am aware that you are from different background, as already I have told you that you are from rural as well as the metropolitan areas, and there may be the problem of language to the rural or the metropolitan student, rural and the remote student. However, the metropolitan students are very good in the English. So for that purpose, I am here to coordinate this gap. The objective of my lecture will be that to make you acquainted with the Constitution of India, and secondly, to make your path of CET easier, so that you will be with confidence appearing the CET examination, which is to be proposed very shortly by the government of Maharashtra and CET cell. With this, let me start my topic. As already I have told you that this lecture will be comprising of only 2 modules, and third, there will be the last 15-minute reserve for the question and answer. And I'll try to summarize my lecture within the time of 45 minutes. Coming to the first aspect of the lecture, that what is Constitution? What is Constitution? And there are many definitions provided by the scholars of the Constitution. And let me tell you that Constitution is nothing but the solemn resolution of the people. And it is one of the scholars of the Constitution who is called as Bolingbroke. We have defined the Constitution in a very easier manner, who opines that Constitution is a solemn resolution of the people by which they want to govern their state. Coming in Marathi, that what is Constitution? Constitution हा एक लोकांनी त्या देशातील लोकांनी केलेला संकल्पपूर्वक निर्धार असतो ज्या ते आपल्या देशाचं सरकार चालू इच्छितात. Secondly, the definition of Constitution is given by the Phillips and Wade. We have very good formulated definition, and they believe that Constitution is a document which has the special legal sanctity, which establishes the principal organ of the government and the principles of their governance. Now here, you have to keep in your mind that Phillips and Wade have formulated their definition considering the form, nature, and purpose of the Constitution. So according to them, Constitution is a document. And what is the purpose of the Constitution? The purpose of the Constitution are to establish the principal organ of the government, and what? Executive and the judiciary. So very first objective of the Constitution is to establish this principal organ of the government, and secondly, the Constitution also has the purpose to let down the principles or to set out the principles according to which this principal organ of the government has to work or has to govern or has to function. So this is the definition of them. So in Marathi, for the rural people, I'll tell you that कॉन्स्टिट्यूशन हा एक दस्तावेज असतो आणि असा दस्तावेज की ज्या दस्तावेजाला लोकांची मान्यता असते आणि तो दस्तावेज गव्हर्नमेंटचे 3 प्रिन्सिपल ऑर्गन जे आपले लेजिस्लेचर, एक्झिक्युटिव्ह आणि ज्युडिशियरी असतात ते एस्टॅब्लिश केले जातात. त्याबरोबरच हे तिन्ही ऑर्गन कशा प्रकारे चालवायचे त्याचे तत्व सुद्धा कॉन्स्टिट्यूशन हे देत असतं. Now coming to the another very good definition which is given by September 1949, Baba Sahib Ambedkar have given the definition of the constitution in very lucid manner, and I'll read that definition which he has made. It is a document of the state. The executive, the judge says, it also defines the powers of the executive and the powers of the legislature as against the citizen. In fact, the purpose of the constitution is not merely to create the organs of the state, but to limit their authority, because if no limitation was imposed upon the authority of the organs, there will be complete tyranny and complete oppression. It means that Dr. Baba Sahib Ambedkar have given 4 features of the definition of the constitution, and firstly, he believed that constitution is a fundamental document. So why it is a fundamental document? Because constitution laid down very important principles of the law of the governance of that territory or the country. In Marathi, according to Baba Sahib Ambedkar, constitution हा एक मूलभूत दस्तावेज असतो. So what kind of this document is? It defines the position and the powers of 3 organs of the government. According to Baba Sahib Ambedkar, this is very important function of the constitution, that it has to define the position and it has to define the powers of the 3 organs of the government. What are those? These are the executive, judiciary and legislature. म्हणजे याचा अर्थ असा झाला की बाबासाहेबांच्या मताप्रमाणे संविधान एक मूलभूत दस्तावेज आहे आणि बाबासाहेबांच्या मताप्रमाणे असा दस्तावेज की सरकारचे हे लेजिस्लेचर, एक्झिक्युटिव्ह आणि ज्युडिशियरी 3 जे प्रिन्सिपल ऑर्गन असतात त्याचे स्थान आणि अधिकार निश्चित करणे. Secondly, the purpose of the constitution, according to Baba Sahib, is to limit their authority. To limit their authority, it means the limiting authority of the executive, judiciary and legislature is the purpose of the constitution. Baba Sahib replies the question that why they should be delimited or why their authority should be limited, and he says that if no such limitations, there will be complete tyranny and complete oppression. जर अशा प्रकारचे निर्बंध लेजिस्लेचर आणि एक्झिक्युटिव्हवर नसतील तर तिथे संपूर्णतः जुलूम आणि संपूर्णतः दडपशाही त्या देशामध्ये राहील. म्हणजे याचा अर्थ लेजिस्लेचर, एक्झिक्युटिव्ह आणि ज्युडिशियरी या तिन्ही गव्हर्नमेंटच्या ऑर्गनचे पोझिशन आणि पॉवर निश्चित करणे आणि पॉवर्स हे डिलिमिट करणे किंवा त्याच्यावर निर्बंध लादणे किंवा बंधने लादणे हा कोणत्याही संविधानाचा महत्वाचा उद्देश असतो. ह्या 3 डेफिनेशन झाल्या. Now considering these 3 definitions of the constitution, we have to discuss the salient features of our own constitution. I hope that you have understood the definition or meaning of the constitution. ज्या अर्थी आपण कॉन्स्टिट्यूशनचा अभ्यास करण्यासाठी सुरुवात करतो किंवा करत असतो त्यावेळेला आपल्याला कॉन्स्टिट्यूशन म्हणजे काय ह्या गोष्टीची पहिल्यांदा माहिती असणं गरजेचे असते. आणि मग त्यासाठी प्रथमतःच मी आपल्याला संविधान म्हणजे काय हे सांगितलंय. मला अपेक्षा आहे की सर्वांना ती संविधानाची संकल्पना कळलेली आहे. Now I'll take you to the salient feature of the Indian Constitution. Here I'll request you that if you have any question, meanwhile that will be communicated to me. I'll try to answer your question. And there are many salient features of the Constitution. You can study this salient feature of the Constitution in different kind of the book. I have with me the book which I like most is written by Dr. Subhash Kashyap, and the title of the book is Our Constitution. It is one of the very good books, and I'll recommend you to go through the book. The beginner of the constitutional study should see that book. But I hope that you are not even beginners. You have to begin your journey of the study of the law in general and the study of the Constitution in particular. So I will be very easier while dealing this lecture. मला जाणीव आहे की तुम्ही अजून कायद्याच्या अभ्यासाची सुरुवात केली नाहीये आणि तुम्ही सुरुवात करण्यामध्ये आहात, त्यामुळे फार अवघड न करता फार सोपा अशा प्रकारचं व्याख्यान करण्याचा माझा मानस आहे. So coming to the salient features, according to Subhash Kashyap, that our constitution is a first constitution in the Indian history which is enacted, adopted and given to ourselves, that is with the people of India. सुभाष कश्यप यांच्या मताप्रमाणे आपलं संविधान हे आपल्या देशाच्या इतिहासातील पहिलं असं संविधान आहे की जे आपण स्वतः निर्माण केलेलं आहे, स्वतः अंगीकृत केलेलं आहे आणि स्वतः प्रत अर्पण केलेलं आहे. आपल्या देशातील ह्या अगोदर जे संविधान तयार झाली होती किंवा फंडामेंटल लॉज ऑफ द लँड तयार करण्यात आलेले होते, ते लोकांनी तयार केलेले नव्हते, ते कुणीतरी दुसऱ्या अथॉरिटीने तयार केले होते, and they were imposed on the we people of India. So accordingly, Subhash Kashyap has this very good view about the constitution, that it is a first constitution which is enacted, adopted and given to ourselves by the people of India. Now, what is the date on which this constitution was adopted, enacted and given to ourselves by the people of India? That date is 26 November 1949. You have to remember this date on which we have adopted, enacted and given ourselves this constitution, 26 November 1949. Our constitution was enforced on 26 January 1950. And this constitution, in this year, we have completed 7 decades of the working of our constitution. Now, during these 70 years of the working of our constitution, we have faced many challenges, many issues, many constitutional, political, social, economic issues which we have faced. But our constitution have proved that to adequate, sufficient for resolving all these problems. This constitution was actually made by the Constituent Assembly of India, which was established on the 9th December 1946. And ultimately, the Constituent Assembly was successful in finishing this task on the 26th November 1949. And after that, on the 24th January 1950, it was signed by the all members of the Constituent Assembly. So, some facts about the Constituent Assembly are that Dr. Babasaheb Ambedkar was the chairman of the drafting committee, and Dr. Rajendra Prasad was the chairman of the Constituent Assembly. These two facts, at least at this stage, you should know. Remaining fact we will be dealing into the class when you will take admission into the LLB course. Now, the period of making of the Constitution of India, which traditionally we know is of 2 years, 11 months and 18 days, from the date 9 December 1946 to 26 November 1949, 2 years, 11 months and 18 days. But actually, according to me, from the date 9th December 1946 to 24th January 1950, it takes 3 years, 1 month and 16 days for completing the task of the making of the Constitution of India. Some other facts in respect of the Constitution which we are going to study are as follows. The Constitution of India is comprised of 1 preamble, 22 parts, 395 articles and 12 schedules. जेव्हा आपण संविधानाचा विचार करतो त्यावेळेस ह्या गोष्टी आपल्याला माहिती पाहिजे की जसं सुभाष कश्यपाने सांगितलं की हे आपलं पहिलं असं संविधान आहे की भारतीय लोकांनी स्वतः निर्माण केलं, स्वतः प्रत अर्पण केलं, जे 26 नोव्हेंबर 1949 ला आपण स्वीकृत केलं. 26 जानेवारी 1950 ला आपण त्याची अंमलबजावणी सुरू करायला सुरुवात केली आणि आज 70 वर्ष होऊन गेलेली आहेत या संविधानाच्या अंमलबजावणीला. संविधानाची निर्मिती डॉक्टर बाबासाहेब आंबेडकर यांच्या अध्यक्षतेखाली असलेल्या ड्राफ्टिंग कमिटी ने आणि डॉक्टर राजेंद्र प्रसाद यांच्या अध्यक्षतेखाली असलेल्या संविधान समितीने केलेली होती. हे आपल्याला काही फॅक्ट माहिती पाहिजे. आपण संविधान निर्मितीला 2 वर्ष 11 महिने आणि 18 दिवस हा पिरियड घेतला. त्यासोबतच मला असं वाटतं त्या 9 डिसेंबर 1946 पासून तर 24 जानेवारी 1950 पर्यंत 3 वर्षे 1 महिना आणि 16 दिवस हे आपल्या संविधान निर्मितीचे होतात. आपल्या संविधानाच्या अनुषंगाने दुसऱ्या महत्वाच्या गोष्टी ह्या आपल्याला माहिती पाहिजे की आपल्या संविधानाच्या रचनेमध्ये महत्वाच्या कोणत्या गोष्टी आहेत. व्हॉट थिंग शाल comprise the Constitution of India and our Constitution is comprising of one preamble. आपल्या संविधानाला एक प्रास्ताविक आहे, 22 भाग आहेत आणि 395 कलम आहेत, आर्टिकल आहेत किंवा परिच्छेद आहेत, 12 शेड्यूल्स आहेत किंवा परिशिष्ट आहेत. And also let me tell you another important fact is that during this 7 decades we have amended our Constitution 104 times. आतापर्यंत या मागच्या 70 वर्षांमध्ये आपण 104 वेळा आपलं संविधान हे दुरुस्ती केलेलं आहे. काही फीचरच्या अनुषंगाने मला सांगण्याचा माझा ऑब्जेक्टिव्ह होता. नाउ आय विल टेक यू what is preamble. Actually, preamble is very essential and integral part of the Constitution of India. Actually, preamble is the very important document to which there is introductory idea about the object laid down by the legislature. So accordingly, under the preamble of our Constitution, the Constitution framework have also very precisely narrated the objectives and purpose of our Constitution of India. So what are the another thing under the preamble of the Constitution? There are many things which are to be called as the foundation of the Constitution, the fundamentals of the Constitution. The basic principles of the Constitution are laid down under the preamble of our Constitution. And let me tell you that what this preamble declares. The preamble declares that we the people of India. Preamble starts from the word we the people of India. It is very important thing to know about the Constitution, particularly the preamble, that start from we the people of India. It means that all authorities of making of the Constitution are derived by the Constituent Assembly by the people of India. So people of India are very important. They are very source of the sovereignty of the state under the Constitution of India, and for that reason, we the people of India praise starts our Constitution. Further, we declare that we the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic and republic. So we want to establish India as a sovereign. We want to establish our India as a socialist, secular, democratic and republic. So what are these ideas? I will discuss that into the course of my lecture when I will come to that point after this. Our preamble declares that there are 4 foundation of our Constitution. Fundamental principles or pillars of our Constitution, and they are justice, they are liberty, equality, and fraternity. You have to be very cautious while talking on these 4, the chronology of these: justice, liberty, equality, and fraternity. So So what kind of justice we want, or what kind of justice is actually to be secured by the state to the people of India according to the preamble, that justice, social, economic, and political. There are three kinds of the justice which we want to secure for the people of India, for the citizen of India. Secondly, we want to give them the liberties of some kind. And what are those liberties? Liberties of thought, expression, belief, faith, and worship. And equality of status and of opportunity. And fraternity. What kind of fraternity? Fraternity assuring the dignity of individual and unity and integrity of the nation. मराठीमध्ये हा इश्यू मी तुमच्यासमोर आणण्याचा प्रयत्न करतो की आपल्या संविधानामध्ये जे प्रास्ताविक आहे ते फार महत्वाचा असा भाग आपल्या संविधानाचा आहे. सुप्रीम कोर्टाच्या अनेक निवाड्यामध्ये हा इश्यू आला होता सुरुवातीला की आपलं प्रिअम्बल आपल्या संविधानाचा भाग आहे का नाही, परंतु जजमेंटने आता डिक्लेअर केलेलं आहे, खास करून केशवानंद भारती ह्या जजमेंट कडे आपल्याला घेऊन जाईल मी, की त्यामध्ये सांगितलं की प्रिअम्बल आपल्या संविधानाचा महत्वाचा भाग आहे, इसेन्शियल अँड इंटिग्रल पार्ट ऑफ द कॉन्स्टिट्यूशन. आपल्या संविधानाच्या प्रिअम्बल मध्ये काय आहे? मग प्रिअम्बल किती महत्वाचं आहे? आपलं प्रिअम्बल जर आपण वाचलं तर संविधानामध्ये काय आहे त्या सर्व गोष्टी तुम्हाला जाणीव होईल. अँड फॉर दॅट रिझन इट इज कॉल्ड एज द विंडो टू एंटर इन टू द कॉन्स्टिट्यूशन. यू कॅन सी with the help of that window what is there into the constitution. आणि आपल्या संविधानामध्ये काय आहेत? मग ह्या चार गोष्टी महत्वाच्या आहेत. आणि भारताला कोणत्या स्वरूपात आपल्याला बनवायचं, जसं मी अगोदर म्हणालो की सॉवरेन सोशलिस्ट सेक्युलर डेमोक्रॅटिक रिपब्लिक, सार्वभौम समाजवादी धर्मनिरपेक्ष लोकशाही गणराज्य भारत घडवणे हा आपला उद्देश आहे. त्यासोबतच सर्व नागरिकांना न्याय, सामाजिक, आर्थिक आणि राजकीय आणि काही स्वातंत्र्य आपल्याला त्या लोकांना द्यायचे अशी आपण ग्वाही दिलेली आहे. समता लोकांना प्रस्थापित करायची, लोकांसाठी प्रस्थापित करायची आहे. कोणत्या प्रकारची? ऑफ इक्वॅलिटी ऑफ अँड इक्वॅलिटी ऑफ स्टेटस अँड ऑफ ऑपॉर्च्युनिटी, दर्जा आणि संधीची समानता. तर बंधुता सुद्धा आपलं हे उद्दिष्ट आपल्या संविधानामध्ये, विच इज देअर फॉर फ्रॅटर्निटीचं काय ऑब्जेक्टिव्ह आहे? फ्रॅटर्निटी ची ग्वाही देणारी बंधुता आणि राष्ट्राची एकता आणि एकात्मता याचं संवर्धन करणारी बंधुता आपल्या संविधानाचे असं संविधान निर्मात्यांनी आपल्या त्या प्रास्ताविकेमध्ये लिहून ठेवलेलं आहे. ही फार महत्वाची गोष्ट आहे. यासोबतच दुसरे काही आपल्या संविधानाचे सायलेंट फीचर मी आपल्या समोर मांडू इच्छितो. आणि जे रूढ अर्थाने खास करून आहेत त्यामध्ये प्रथमतः आम्ही असा विचार करत असतो की दॅट कॉन्स्टिट्यूशन ऑफ इंडिया इज अ बल्की अँड रिटन डॉक्युमेंट. द कॉन्स्टिट्यूशन ऑफ इंडिया इज व्हेरी बल्की. इन मराठी विस्तृत अशा प्रकारचा हा दस्तावेज आहे. अँड वाय? बिकॉज द कॉन्स्टिट्यूशन ऑफ इंडिया हॅज व्हेरी डिटेल्ड प्रोव्हिजन ऑफ different kind of the legislative matter under the constitution to be governed by this state. इतके महत्वाचे अनेक गोष्टीचा उहापोह आपल्या संविधानामध्ये जे पुढे आपण डिस्कस करणार आहेत त्या सर्व बाबी. यासोबतच आणखी एक महत्वाची गोष्ट मी तुम्हाला सांगेन, जसं सुभाष कश्यपांचा मी उल्लेख अगोदरच केलेला आहे. अँड हु सेज that our constitution not only provides for the constitution of the union but it also provides for the constitution of the state. Normally what happens that either constitution is federal polity or unitary government and it will be left for the provinces of the state to have United States of America. परंतु आपल्या संविधानामध्ये दोन्ही फेडरल म्हणजे युनियन भारतीय स्तरावर राष्ट्रीय स्तरावर असलेलं सरकारची रचना आणि राज्य स्तरावर असलेल्या सरकारची रचना या दोन्ही स्तरांचं संविधान देण्याचा प्रयत्न केलेला आहे. यासोबतच आपल्या संविधान करणार आहेत ज्या फंडामेंटल राईट असतील, डायरेक्टिव्ह प्रिन्सिपल्स असतील किंवा त्यासोबतच आपण पुढच्या काही लेक्चर मध्ये बघणार आहेत. ह्या लेक्चर मध्ये सुद्धा त्याच्यावर काही फोकस करण्याचा मी प्रयत्न करणार आहे. नाउ कमिंग टू the establishment of India as a sovereign, socialist, secular, democratic republic. Friends, you should very cautious to understand this terminology that our people of India, the founding father of the constitution, wanted that India should be the sovereign India. Sovereign India means the sovereign is that authority which is not actually under the compulsions of the directions or mandate of the other like sovereign. So भारत एक सार्वभौम अशा प्रकारचा देश आहे, राष्ट्र आहे. आपल्याला बाकीच्या कोणत्याही अशा प्रकारच्या राष्ट्रांचे कोणत्याही प्रकारचे निर्बंध बंधनकारक करून घेण्याची काही आवश्यकता नाही. Being we are the sovereign. Then we are the socialist. What socialist means? Actually, socialist, though the term include the word socialist, which is having the idea of the society, but it is actually the economic term. जरी सामाजिक अशा प्रकारचं हे टर्म आहे तरी सुद्धा ह्याला एक सामाजिक अर्थापेक्षा आर्थिक जास्त अर्थ आहे. त्याचं कारण असं आहे की that there are actually many kinds of the economy, and particularly there may be the socialist economy or the capitalist economy, or there may be the mixed kind of the economy. Our constitution wanted that there will be the socialist kind of the economy. And what are the picture of socialist kind of the economy? That the resources of all income shall be owned by the people, shall be owned by the society, and the benefit of that should be utilized for the people of that state. And further it said that it is secular. Secular, what secular means? Secular means the state will not have any kind of the official religion. And it is fact about the state under our constitution that we don't have the official religion of the government of the India, or the state which is established under the constitution of India. And it has the equal treatment to all the religion. Actually, secularism into the traditional meaning is negation of the religion. But we have the positive aspect of the secularism under the constitution. We provide the fundamental right to religion to all the citizens of India in our country. Then democratic and republic. What democratic means? Constitution, probably you are aware about the definition of the democracy, and democracy according of the people, by the people, and for the people. Let me make you aware about the concept of the democracy of Babasaheb Ambedkar, who is the founding father of the constitution, who is one of the chief architect of the constitution, who believed that democracy is the form of government by which there will be the revolutionary changes into the social and economic life of the individual without bloodshed. डॉक्टर बाबासाहेब आंबेडकरांच्या मतानुसार लोकशाही अशा प्रकारची एक शासन पद्धती आहे की ज्या योगे व्यक्तीच्या सामाजिक आणि आर्थिक जीवनामध्ये कोणताही रक्तपात न करता क्रांतिकारक बदल घडून येतील. डॉक्टर बाबासाहेब wanted that kind of democracy will be established according to the Constitution of India, and accordingly we have provided the provisions under our constitution. Republic India. What is republic? ज्याला आपण प्रजासत्ताक असं म्हणतो. Now I'll take you to the fact in UK for considering this. What is the position in UK under the constitution? That the head of the state, the constitutional head of the state, who is king or the queen or crown, is always through the royal family. But in India, the constitutional head of the state is elected by the people. It may be indirectly elected by the people, but there is no royal family recognized under the Constitution of India for giving birth to the king or the president, which is to be sworn in and under the Constitution of India. मी आपल्याला दुसरी फॅक्ट सांगेन की भारतामध्ये ह्या सर्व गोष्टी जसं म्हणालो मी की सार्वभौम, समाजवादी, धर्मनिरपेक्ष, लोकशाही गणराज्य भारत घडवणे आपला उद्देश आहे. आणि त्यामध्ये रिपब्लिक किंवा प्रजासत्ताक आपण बघत होतो. ह्याचा अर्थ आहे की लोकांची सत्ता असेल, लोकांमधूनच ते राज्य चालवण्यासाठी जो संविधानिक प्रमुख असतो तो निवडून दिला जाईल. ह्यात काही बाबी इथे थोडक्यात आपल्या समोर मांडाव्यात असा माझा उद्देश होता. Now the another feature of our constitution is that there is the provision for fundamental rights. Part 3 of the Constitution of India provides for the fundamental rights. And these fundamental rights are enumerated under our Constitution from Article 12 to Article 35. मी आपल्याला सांगेन की भाग 3 मध्ये जर आपण बघितलं तर आपल्या संविधानामध्ये मूलभूत हक्कांच्या तरतुदी आहेत. आता हे मूलभूत हक्क कोणते असतील, कशा प्रकारे असतील, हे सर्व विवेचन ऍडव्होकेट चैतन्य धारोरकर आपल्या व्याख्यानामध्ये देणार आहेत, म्हणून तो भाग आपण इथे रिझर्व करणार आहे. बट निदान हे अधिकार कशाचे असतात, कोणाला असतात, हे आपल्याला इथे माहिती असणं गरजेचं आहे. सो दिस फंडामेंटल राईट आर अवेलेबल टू द सिटीजन. Though they are available to the citizen, but they are also available, some fundamental rights are also available to the people who may not be the citizen or person. The term which we have used in many articles, that fundamental rights are available first to the citizen or secondly to the person. Person may be the citizen or not. Person may be the citizen or foreign line, or sometimes person may be the natural person or artificial person. So you have to take care of this. जरी फंडामेंटल राईट हे भारतीय नागरिकांना उपलब्ध असते तरी सुद्धा काही मूलभूत अधिकार हे व्यक्तीला उपलब्ध असतात. आणि तो व्यक्ती एखाद्या वेळेला नागरिक असू शकेल किंवा मध्ये. And these fundamental rights, I was telling you that, are available to the citizen. मग सिटीजन कोण असतात? भारताचे नागरिक जे असतील त्यांना हे मूलभूत अधिकार उपलब्ध So there was disturbance. I was actually there was phone call to me, but I have cut down that. मूलभूत अधिकार हे नागरिकांना राज्याच्या विरुद्ध असतात, ही गोष्ट मी तुम्हाला सांगत होतो. तो नागरिकांना उपलब्ध असतात आणि राज्याच्या विरुद्ध उपलब्ध असतात. तो दुसरी गोष्ट महत्वाची असते संविधानाचा अभ्यास करत असताना, की दॅट व्हॉट इज स्टेट अँड द डेफिनेशन ऑफ द स्टेट इज प्रोव्हाइडेड अंडर द कॉन्स्टिट्यूशन ऑफ इंडिया अंडर आर्टिकल 12. जर 12 नंबरचा आपण परिच्छेद बघितला, आर्टिकल बघितलं, तर त्यामध्ये स्टेट कोण आहे, म्हणजे कोणाच्या विरुद्ध आपल्याला हे अधिकार उपलब्ध आहेत त्याची मांडणी केलेली आहे. म्हणजे याचा अर्थ ते स्टेटच्या विरुद्ध आहेत. जे जे गोष्टी, जे जे गव्हर्नमेंटचे इन्स्ट्रुमेंटॅलिटीज असतील ते डेफिनेशन मध्ये 12व्या आर्टिकल मध्ये येतील, ते सर्व स्टेट असतील आणि त्यांच्या विरुद्ध आपल्याला हा मूलभूत अधिकार उपलब्ध असतो. पुढच्या फंडामेंटल राईटच्या लेक्चर मध्ये तुम्हाला त्या बाबी जास्त स्पष्ट होतील. आफ्टर दॅट अनदर फीचर ऑफ आवर कॉन्स्टिट्यूशन इज दॅट there is a provision of directive principles of state policy. In part 4 of the Constitution of India, it provides for the directive principles of state and policy, state of policy. राज्याचे नीती निर्देशक तत्वे 4थ्या भागामध्ये आपल्या संविधानामध्ये आहेत. आर्टिकल 36 ते 51, from article 36 to 51, there are the directive principles into this part 4 of the Constitution. But what is purpose of this directive principle of state policy? While discussing this, Dr. Babasaheb Ambedkar have described, cleared to the Constituent Assembly the purpose of these directive principles, and he said that we want to establish by the directive principle of state policy in India the parliamentary democracy. So establishment of the parliamentary democracy is also one of the salient feature of our Constitution. And what is parliamentary democracy? Is that political democracy, economic democracy, and social democracy. And also it includes the one man, one vote, one value. And the purpose of this democracy, political democracy, social democracy, or economic democracy, or parliamentary democracy, or very purpose of the directive principle of state policy is that to establish the one man, one vote, one value. And this is very important principle, doctrine, which is laid down under this part 4 for the social revolution. सामाजिक क्रांती ह्यामधून येण्यासारखे हे प्रयोजन आहेत. आणि डॉक्टर बाबासाहेब आंबेडकरांनी ह्या गोष्टीवर महत्वाचं फोकस केलेला होता, ही मी आपल्याला जाणीव करून दिली. यावर सुद्धा सविस्तर विवेचन पुढच्या वेळामध्ये तुम्हाला बघायला मिळेल. आणि ह्यासोबतच भाग 4A मध्ये 4A, part 4A, our constitution provides for the fundamental duties. These fundamental duties which we have now under the Constitution of India are provided according to 42nd Amendment in their 1976. So before that there was no such kind of the part under fundamental duties, and these fundamental duties are also important for the citizen, and these are provided. Very important provisions are these. So considering these three provisions, part 3rd, part 4, and part 4A, you'll see that there is a very good coordination we have tried to establish under our constitution so far as the rights, fundamental rights of the people, the directive principle of the policies that we call as DPSPs, and the fundamental duties. So लोकांना केवळ मूलभूत अधिकार आपल्या संविधानाने दिलेले नसून त्यासोबतच आपलं संविधान त्यांना काही मूलभूत कर्तव्य सुद्धा देतं. म्हणजे आपल्याला फंडामेंटल राईट घ्यायचे आहेतच आणि राज्याची ती जबाबदारी आहेच, परंतु आपलं सुद्धा काही मूलभूत कर्तव्य आहेत जे आपल्या संविधानामध्ये आज रोजी फंडामेंटल ड्युटीज 51A या तरतुदीमध्ये किंवा भाग 4A पार्ट 4A ऑफ द कॉन्स्टिट्यूशन आपल्या संविधानामध्ये जे 42व्या घटना दुरुस्तीने आले. आपल्याला हे ध्यानात ठेवायला पाहिजे की दॅट दिस फंडामेंटल ड्युटीज are incorporated under our constitution according to 42nd Amendment in their 1976. And these are some salient feature. With this, I'll take you to the another feature of our constitution, that there is a establishment of federation with unitary tendency. So, while starting the study of the constitution, as Baba Sahib said that there are two fundamental questions before the student of constitutional law, that what is nature of your constitution and what is the form of your government. त्यामधला पहिला भाग असा मी तुम्हाला सांगेन जो फेडरेशनच्या अनुषंगाने आहे की ज्यावेळेस आपण संविधानाचा अभ्यास करतो आपल्याला पहिला प्रश्न असतो की आपलं संविधानाचं स्वरूप काय आहे, whether that constitution is federal or whether that is unitary. So far as our constitution is concerned, according to the scholar of the constitutional law, our constitution is a federal constitution. But if you see Article 1st of the constitution, which declare that India, that is Bharat, shall be a union of states. So we have used the word union in the Article 1st. Union, but in practice we are the federation. पण युनियनचं सुद्धा काही ऑब्जेक्टिव्ह आहेत ते आपल्याला या प्रसंगी सर्व त्या गोष्टी इथे डिस्कस होऊ शकणार नाहीत, परंतु फॉर द सेक ऑफ मेंटेनिंग युनिटी अँड इंटिग्रिटी ऑफ द नेशन वी हॅव यूज द वर्ड union for our federation. But the real nature of our federation is that it has some unitary tendency. ज्यावेळेला मी तुम्हाला emergency provision सांगेन पुढच्या या भागामध्ये आजच्या लेक्चरच्या, so emergency provisions are nothing but some unitary features under our constitution. So federation म्हणजे काय असतं, ऍक्च्युली आपल्या कॉन्स्टिट्यूशन मध्ये फेडरल सेल जे आपण एस्टॅब्लिश केलं आहे, सो फेडरेशन मीन्स द डिस्ट्रीब्युशन ऑफ पॉवर्स इन बिटवीन द सेंटर अँड द स्टेट. Federation means the sovereignty, the supremacy to the constitution, and it is a fact that our constitution is supreme. But we have federation that the government of India or the parliament have some authorities by which they can control the state. So for that reason our constitution is called as the quasi-federal sometimes, or the federation with unitary tendency, or federation with the powerful or strong center, आपलं अशा प्रकारचं फेडरेशन. ऍक्च्युली फेडरेशनच्या सिस्टीम मध्ये राज्य आणि केंद्र हे दोन्हीही सारख्या स्तरावर असतात, परंतु आपल्या फेडरेशन मध्ये युनियन टेरिटरी किंवा युनायटरी टेंडन्सी आपण स्वीकारलेली आणि सेंटर जास्त पॉवरफुल करण्यात आहे. जर आपण आपल्या संविधानाचे पार्ट 11 आणि पार्ट 12 बघितले, 245 ते 265 आणि 264 ते 300 ए पर्यंत, तर ह्या बाबीची आपल्याला जाणवेल की दॅट आवर कॉन्स्टिट्यूशन इज ए फेडरेशन विथ युनायटरी टेंडन्सी. Next feature will be the unique blend of flexibility and rigidity. See, our constitution has the amendment provision under 368, part 20 of the constitution, which provides the power and procedure for the amendment. And why there should be the amending provision? See, there are generation has to go on and generation has to come, but constitution will remain. So in that case, constitution should be self-sufficient to face the challenges of the given time and given generation. So for that purpose, we should have the amendment provision under the same. And accordingly, our constitution has the amendment provision under 368. आपल्या संविधानामध्ये सुद्धा घटना दुरुस्तीची तरतूद आहे, ज्याचं प्रोविजन आहे 368 मध्ये. कशासाठी घटना दुरुस्ती तरतूद पाहिजे? 368 मध्ये आपल्या संविधानामध्ये तरतूद आहे. त्याचं कारण असं आहे की जनरेशन येतात, पिढ्या जातात, परंतु संविधान तेच राहतं. टाइम बदलतात, वेळ बदलतो, प्रश्न बदलतात, त्या लोकांच्या अपेक्षा बदलतात, आकांक्षा बदलतात, आणि म्हणून मग आपल्याला त्या काळामध्ये संविधानाला सक्षम बनणं गरजेचं असतं, त्या गरजानुसार, त्या प्रश्नानुसार. आणि त्यासाठी मग त्यावेळेच्या संसदेला आपल्या संविधानामध्ये अमेंडमेंटची तरतूद करण्यात आली, जेणेकरून ते आपल्या संविधानामध्ये काही दुरुस्त्या करू शकतील. But it is also fact that this amending authority of the parliament is subject to the basic structure of the constitution. आपल्या संविधानाला काही बेसिक स्ट्रक्चर्स आहेत आणि त्या बेसिक स्ट्रक्चरला अधीन राहून आपल्या संसदेला आपल्या संविधानामध्ये घटना दुरुस्ती करता येऊ शकते. Then there is under our constitution we have adopted parliamentary form of the government. ज्याच्यावर मी अगोदरच बोललो, आता तो पुन्हा मी काही रिपीट करत नाही, परंतु प्रत्यक्षात आपल्या संविधानामध्ये कुठे आहे हेच मी तुम्हाला सांगेन की दिस पार्लमेंटरी फॉर्म ऑफ द गव्हर्नमेंट वी हॅव इनकॉर्पोरेटेड अंडर अवर कॉन्स्टिट्यूशन इन पार्ट 5 अँड पार्ट 6. व्हॉट इज पार्ट 5? द युनियन, ज्यामध्ये लेजिस्लेचर, एक्झिक्युटिव्ह आणि ज्युडिशियरी युनियन स्तरावर, भारतीय स्तरावर किंवा फेडरेशन स्तरावर कसं असेल, त्याचं स्वरूप काय असतील, कशा प्रकारे त्याची रचना असतील, ते आर्टिकल 52 to 151, 52 ते 151 मध्ये आपल्याला युनियन, भारतीय संघराज्याची रचना कशी आहे, लेजिस्लेचर कसं, संसद कशी रचना झालेली आहे, दोन्ही सभागृहाची कशी रचना आहे, एक्झिक्युटिव्ह कसे आहेत, राष्ट्रपती, उपराष्ट्रपती, त्यांच्या नियुक्त्या, अधिकार कशा प्रकारचे काढायचे, ह्या अनेक तरतुदी या पार्ट 5 मध्ये आपल्याला बघायला मिळतील. त्यासोबतच द स्टेट पार्ट 6 ऑफ द कॉन्स्टिट्यूशन अँड आर्टिकल्स आर 152 to 237, in which you will see that there is also the parliamentary form of the government is established at the level of the state. केवळ भारतीय स्तरावर, राज्याच्या केवळ फेडरेशन स्तरावर किंवा राष्ट्रीय स्तरावरच पार्लमेंटरी फॉर्म एस्टॅब्लिश करण्यात आलेला नाही, तर तो या खालच्या राज्याच्या स्तरावर सुद्धा असतो. आणि महत्वाचा धागा काय असतो पार्लमेंटरी फॉर्म ऑफ द गव्हर्नमेंट? इट मीन दॅट द गव्हर्नमेंट इज रिस्पॉन्सिबल टू द पार्लमेंट. In the case of the state, the government is responsible to the legislative assembly. Ultimately, the government should be responsible to the lower house of the people, lower house of the legislature. And for that reason, that is one of the very basic feature of the parliamentary form of the government, wherein the responsibility of the government will be taken into care rather than the stability of the government. Parliamentary government मध्ये कोणत्या प्रकारला महत्व असतं? गव्हर्नमेंटची जबाबदारी काय आहे? जबाबदार सरकार महत्वाचं असतं. स्टेबल गव्हर्नमेंट पेक्षा जबाबदार गव्हर्नमेंट, रिस्पॉन्सिबल गव्हर्नमेंट, स्थिर सरकारपेक्षा जबाबदार सरकारला महत्व असतं पार्लमेंटरी गव्हर्नमेंटमध्ये. तुम्ही जर पार्ट 5 आणि 6 अभ्यास केला, पुढे भविष्यात आताच्या स्तरावर फक्त तुम्हाला ह्या काही प्राथमिक बाबी माहिती असणं गरजेचं आहे असं मला वाटतं. अनदर फीचर ऑफ आवर कॉन्स्टिट्यूशन इज द सिंगल सिटीजनशिप. अंडर आवर कॉन्स्टिट्यूशन देर इज ओनली सिंगल सिटीजनशिप. यू आर द सिटीजन ऑफ इंडिया. and you are not the citizen of your state. You may be the resident of your state, but we are only the citizen of India. It means that we have single citizenship. Normally into the federation, what happens that the citizen will be of that particular state and citizen will also be of the federation. But according to Article 5 of our Constitution Part 2, Article 5 to 11, there is citizenship provision and accordingly we have single citizenship. Again, our Constitution establishes independent judiciary. I will finish within 5 to 7 minutes. You please bear with me. I know that time is running. There is independence of judiciary under the Constitution of India, and according to the Article 50, which give mandate to the states that they have to take care that there will be the independence of judiciary. If you see the provision of our Constitution, you will see that the judiciary under our Constitution is independent. No way it is under mandate of the parliament reason, the guarantee of justice is with the people. For that reason, they can secure. The feature of our Constitution is that there is adult franchise or adult suffrage, or elections are on the basis of adult suffrage or adult franchise. And according to 326 of our Constitution, at the age of 18 years who are given the right to vote or right to register. That is the terminology. Let me tell you that if you have completed your 18 years of age, you will be entitled for registering your name as a voter. As right to vote, but you have right to register your name. And by voter, you will get the right to vote into the general election or whatever election may be. The provision is 326 in Part 15 of the Constitution. And second large feature which is with me is that emergency provision. Our Constitution has emergency provision under Part 18 from Article 352, 352 पासून तर 360. So emergency provisions are those provisions wherein in some emergency situation, President of India can proclaim the emergency. And there are three kinds of the emergencies under the Constitution of India. There is national emergency, there is state emergency, and there is financial emergency. And last but not the least, I will conclude my lecture with this last salient feature, that provision for the panchayat. There is also the provision for municipalities, and there is also provision for the cooperative society. See how the detailed provisions in respect of not only the union or the state, but our Constitution take care of the panchayat. आपल्या जे सर्व पंचायती राज सिस्टम आहे, according to 73rd and 74th Amendment of 1992, we have incorporated this new provision of Panchayati Raj, that is the Part 9 of the Constitution and 9A of the Constitution, wherein there is Panchayati Raj at the rural level and there is municipalities at the urban level. And cooperative societies. Very recently, according to 97th Amendment into 2011, we have amended our Constitution and inserted these provisions in respect of the cooperative societies. 9B of the Constitution. It means that our Constitution not only provides for the constitution of the union or of the state, but it also provides for the constitution of the Panchayati Raj, that Panchayat, Jilla Parishad, intermediate panchayat, and even the village panchayat. These provisions are there under the Constitution of India. With this, the constitution of the municipalities, the municipal corporations and other municipalities, there is the constitution of our Constitution has very detailed provision in respect of the cooperative societies. According to this 97th Amendment of 2011, there is the amendment, and we have inserted the cooperative societies not only into the fundamental right. We have the fundamental right to establish the cooperative societies also, along with the fundamental freedom of establishment of your associations and unions. With that, we have fundamental right to establish the cooperative society. So these are some challenge feature of our this lecture. The definition of the Constitution, not to something but the document which establishes principal organ of the government and sets out the principles of their governance, and the salient feature of the Indian Constitution discuss with you. Now I'll open this session for the question and answer. Dr. Vassar or Madhuri or anybody can ask me the question. I'll try to reply the same.
Thank you, sir.
Yes, sir.
Some reactions has been given by student that today's lecture is very informative. And
Good.
shall we start question answer? Okay.
Yes.
One question is that what is act? Are there act in Constitution?
Good question. I think I need not to summarize into Marathi now because I have dealt with the topic in Marathi as well as in English. Okay. So I will reply to your question that what is act? Act, A capital and CT, small ct. So act means the enactment or the legislation which is made by the legislative organ of the state, say parliament or legislative at the state level, legislative assembly and legislative council. मराठीमध्ये मी सांगेन की ऍक्ट ज्याला तुम्ही म्हणता तो लेजिस्लेटिव्ह ऑर्गन तयार करत असतात. त्याचं स्पेलिंग लिहित असताना ए कॅपिटल लिहायचं. ज्या वेळेला तुम्ही स्मॉल ए सी टी लिहिता इट इंडिकेट आपली कृती ऍक्शन, बट यू शुड टेक केअर दॅट ए सी टी शुड बी कॅपिटल while writing the act. Okay, difference between act and law, another question is appear before me. So actually law is very general concept and act is the particular one from that law. So I think you are clear with this. मराठीमध्ये सांगेन की ज्या वेळेला आता संविधान जर म्हटलं आपण, whether constitution is an act or whether it is a law or whether it is a another kind of the piece of legislation. So constitution आणि बाकीच्या ऍक्ट मध्ये फरक हा आहे की दॅट जे कोणते कायदे पार्लमेंटने बनवलेले असतात त्याला आपण ऍक्ट म्हणतो किंवा एनॅक्टमेंट म्हणतो. ज्या वेळेला आता कॉन्स्टिट्यूशन जर विचार केला आपण तर कॉन्स्टिट्यूशन इज मेड बाय द कॉन्स्टिट्युएंट असेंब्ली अंडर देअर कॉन्स्टिट्युएंट अथॉरिटी. सो कॉन्स्टिट्यूशन देअर बाय इज लॉ, a fundamental law of the land, a supreme law of the land. However, your other acts, say for an example, Citizenship Act or People's Representation Act, these are the pieces of legislation to which you have to call as an act. Thank you, sir.
Sir, another question is what is democracy?
Good. Democracy, I think I have discussed the definition of democracy, but particularly the constitutional democracy, I think you are expecting. And democracy, as already I have told you, that is the form of government by which there will be the revolutionary changes into the social and economic life of individual without bloodshed. That was told by Babasaheb Ambedkar. लोकशाही अशी शासन पद्धती असते ज्या योगे व्यक्तीच्या सामाजिक आणि आर्थिक जीवनामध्ये कोणताही रक्तपात न करता आमूलाग्र किंवा क्रांतिकारक बदल घडून येतात. अब्राहम लिंकनच्या मताप्रमाणे लोकशाही म्हणजे लोकांनी लोकांसाठी चालवलेलं सरकार, जे आपल्या संविधानामध्ये आपलं पार्लमेंटचं स्ट्रक्चर बघितलं, लोकसभेमध्ये आपण आपले प्रतिनिधी पाठवतो आणि ते आपलं सरकार चालवतात. याचा अर्थ देर इज ए डेमोक्रेसी वी हॅव अडॉप्टेड अंडर द कॉन्स्टिट्यूशन.
Sir, another question is that what are subsection related to 4 pillars of Constitution?
So there are many, so there should be correction into the question that these are not the sections, these are articles. Okay, and you should call this as an article, not as a section. So in act or the legislation, we normally call them as a section. While talking of the constitution, we use the word articles. So there are many articles under our constitution which are giving effect to the four foundations or four pillars of our constitution, that are justice, liberty, equality, and fraternity. If you can see, article 14 to 18, these are the equality provisions. So we have given effect to the equality of status and of opportunity under this fundamental rights to equality. If you can see the provision of article 15.4 and 16.4, this provides for the reservations. So these are in respect the social justice particularly. If you can see the provision of 38 and 39 of our constitution under the directive principle of state policy, they are also for providing or promoting the justice to the people. Many provisions are there under the Constitution of India which are giving effect to this four foundation of the constitution. Fraternity, so far as the fraternity in the directive principle of state policy and the fundamental duties, you will see the provisions in respect of the fraternity. Liberties or the freedom, there is article 19, 20, 21, 22. These provisions are promoting your liberties, the freedoms which are guaranteed to you by the nature, not only the state. Then these are many provisions. While talking on these provisions, you will be very clear with these provisions which are giving effect to the four foundation of the preamble of our constitution or constitution ultimately. Yes, sir.
सर दुसरा प्रश्न आहे, स्टेटचा उल्लेख जसा 12 आर्टिकल मध्ये आहे त्याप्रमाणे कोणत्या आर्टिकल अंतर्गत कोणत्या संज्ञेचा उल्लेख आहे यावर प्रश्न विचारले जातील का?
Yes, definitely. I hope that there should be question not only in CET but in many competitive examinations, maybe your UPSC or UPSC or any other staff selection examination. I hope that there should be the question on the concept of the state. It is very dynamic concept. So you should be aware with the concept of the state. As already I have told you that what is state under article 12 of the constitution and what is importance of the definition of the state, that it is provided there for against whom the fundamental rights are available, and state according to this is the government of India, the parliament of India, the government of the state legislature and other authorities which are under the control of the government of India. It means that other authority which may not be the government or the parliament or may not be the government of the state or the legislature, even though you are BSNL, which is the instrumentality of the state, is the state under the constitution. Like your BSNL or the government for the sectors, your public sectors, PSUs are also the state under the definition of the state under article 12.
Sir, another question is, what is federalism?
So federalism is actually the scheme of the setup of the polity, and the federalism particularly is that idea wherein there is distribution of the legislative, administrative and financial powers in between the union and the state government, which is very essential. There are some essentials of federalism. बघा फेडरलिझम म्हणजे काय असतं की फेडरलिझम मध्ये जसे दोन प्रकारचे गव्हर्नमेंट असतात. तुम्हाला माहिती आहे की आता राज्य सरकार आहे आणि केंद्र सरकार आहे. मग केंद्र सरकार आणि राज्य सरकार याच्यामध्ये समन्वय राहण्याच्या दृष्टिकोनातून त्या दोघांचेही अधिकार कक्ष काय आहेत, कायदा बनवत असताना किंवा प्रशासन चालत असताना किंवा आर्थिक बाबीमध्ये त्याची एक रचना तयार करणे, संरचना तयार करणे किंवा एक स्कीम तयार करणे, ज्याला आपण डिस्ट्रीब्युशन ऑफ पॉवर असं म्हणतो, फार महत्वाची गोष्ट असते ही. त्याला नॉर्मली फेडरलिझम म्हणतात. आपल्या संविधानामध्ये पार्ट 11 मध्ये आपण अभ्यास त्याचा तुम्ही करणार आहात, ज्यामध्ये हे डिस्ट्रीब्युशन ऑफ पॉवर महत्वाचं असतं. आणि फेडरेशनसाठी दुसऱ्या ज्या बाबी महत्वाच्या आहेत त्यामध्ये खास करून कॉन्स्टिट्यूशन तुमचं लेखित व्हायला पाहिजे. त्याच्यातच कॉन्स्टिट्यूशन शुड बी सुप्रीम, अथॉरिटी टू द कोर्ट हे एक महत्वाची गोष्ट असते, आणि कॉन्स्टिट्यूशन शुड बी रिजिड. ह्या 5 गोष्टी फेडरल कॉन्स्टिट्यूशन साठी किंवा फेडरेशन साठी महत्वाच्या असतात. मला वाटतं तुम्हाला कळालेलं आहे. येस
सर, शेवटचा प्रश्न माझ्याकडे आहे आणि त्यानंतर माधुरी विचारेल. शेवटचा प्रश्न आहे, व्हॉट इज पार्लिमेंटरी गव्हर्नमेंट?
What is parliamentary government? Good question. See, I have already referred to you Babasaheb Ambedkar, who had talked on the form of the government. And he had said that if a constitution is placed in the hand of the student of the constitutional law, there will be two fundamental questions: that what is nature of your constitution and what is the form of your government. So there are basically two forms of the government. One is the presidential form of the government and another one is the parliamentary form of the government. So before discussing the parliamentary form of the government, I will take to you to the presidential form of the government, which means that if there is all authorities, executive nature of the authorities are with the president, and if president is directly elected by the people who become the real executive of the state, it is the presidential form of the government. In case of the parliamentary form of the government, which we have, that is West Ministerial model of the government, and wherein the liability towards the parliament in general or particularly to the lower house of the parliament. In case of the India, the government is responsible to the lower house, which is the Lok Sabha, house of people, and there is responsibility of the government is more important. In case of the parliamentary form of the government, while into the presidential form of the government, there is importance is given to the stability and executive powers are given to the president. In the parliamentary form of the government, real executive is the prime minister, actually, who is coming from the lower house of the parliament or any other house of the parliament, and but whose responsibility is toward the lower house of the parliament, that is Lok Sabha. मराठीमध्ये मी सांगण्याचा प्रयत्न करतो, पार्लमेंटरी किंवा संसदीय फॉर्म ऑफ गव्हर्नमेंट मध्ये सरकारची जबाबदारी किंवा उत्तरदायित्व हे संसदेच्या खालच्या सभागृहाकडे किंवा कनिष्ठ सभागृहाला असतं, कारण ते लोकांमधून निवडून येतात. ज्या वेळेला त्यांच्या संसदेमध्ये त्यांच्याकडे मेजॉरिटी नसते किंवा त्यांच्यावर विश्वास नसतो, अविश्वास असतो, त्यावेळेला कोणत्याही सरकारला सरकारमध्ये राहता येत नाही. इफ यू आर नॉट confidence into the house, you have to vacate from your authority. That is particularly the parliamentary democracy. Thank you. Yes, Madhuri.
Yes, sir.
Yes, good.
Sir,
do you have any questions with you?
Yes, sir. Yes, sir. Sir, first question is, what does it mean by liberty of thought?
Good. What is liberty of thought? It is very crucial question, I believe. So liberty of thought, particularly thought in mind. Okay. So far as liberty is concerned, which is given under the preamble of constitution expression, what we have called is that कशाचे स्वातंत्र्य, आपल्याला विचार करण्याचं स्वातंत्र्य आणि अभिव्यक्तीचं स्वातंत्र्य, थॉट अँड एक्सप्रेशन. परंतु ज्या वेळेला तुम्ही थॉटचा विचार करता, आय विल रीड दिस विथ 25 ऑफ आवर कॉन्स्टिट्यूशन. केवळ तुम्हाला प्रिअम्बल मध्ये विचार करण्याचं स्वातंत्र्य असणे आणि नसणे, मला सांगा, तुम्ही जर विचार करण्याचं स्वातंत्र्य संविधानाने आपल्याला दिलं नाही, तर याचा अर्थ आपण विचार करायचं सोडून देणार का, ह्युमन बिईंग म्हणून किंवा नॅचरल ह्युमन बिईंग म्हणून? पण तरी सुद्धा आपल्याला वैचारिक स्वातंत्र्य आहे, ज्या वेळेला देशामध्ये वेगवेगळ्या विचारधारा आपल्या राहतात. सी, दिस लँड इज ऑफ मेनी डायव्हर्सिटीज. वी हॅव डायव्हर्सिटीज इन द मॅटर्स ऑफ द रिलिजन, वी हॅव डायव्हर्सिटीज इन द डिफरंट काइंड ऑफ द मॅटर्स, अँड वी हॅव डायव्हर्सिटीज इन काइंड ऑफ द ideologies. So far as thinking process, so far as belief, faith. See, liberty of thought is not only with thought, but it also related with the belief and faith, isn't it? So these are internal matter. But you have under the Constitution of India, the liberty of thought. Under 19 of our Constitution, it gives effect to your liberty of thought, which is actually providing you the fundamental freedom of expression by of speech and by any other kind of the media. Like today's our endeavor, we are on the Zoom, isn't it? Live on YouTube and Facebook. These are also some media for expressing ourselves. Whatever thought in our mind, we can express through our speech or through print media or through your writing or any drawing or any kind of the gesture, but that are subject to the reasonable restrictions. Next.
Okay. Thank you, sir. Sir, the second question is,
Good.
how are directive principles of state policy are different to articles in the Indian
Fundamental right.
Constitution?
Good. So basically, there is a fundamental difference in between directive principles of state policy and the fundamental right. See, fundamental rights are enforceable or justiciable, what we call.
No, sir. Hello,
Uh,
sir.
question is that how they are different then?
There is a mistake actually. Sir, there is some small mistake. How are directive principles of state policy are different to articles in the Indian Constitution?
Yes, yes, that what I am.
That is the question, sir.
That's what I am replying. How they are different
Okay.
than the other provision of Constitution. Particularly, they are different than the fundamental right only. So before that, you should know the nature of fundamental right. So that you will get the you will come to know the difference in between the fundamental right and directive principle. Fundamental rights are enforceable, what I was telling you. However, directive principle are not. They are not enforceable through the court. If your fundamental right is violated, you can approach to the Supreme Court of India. And Supreme Court of India under Article 32 have the right to issue the writ. In the last lecture itself, it's told to you by Dr. Anju Singh ma'am while discussing with the writ. But so far as the directive principle of state policy, such kind of the remedy to go into the court for the enforcement of the directive principle is not provided under a constitution. It means that they are not enforceable by law under the constitution. However, there is a political enforcement available to the directive principle. And what kind of the political enforcement? So discussing on this directive principle and particularly on the issue of the enforcement, which is particularly differentiating this directive principle with the fundamental right, Baba Sahib said that these are different, and though there is no remedy for enforcement like fundamental right to this directive principle, but there is a political remedy for the enforcement of the same. Yes, next one.
Okay. Thank you, sir. Sir, the next question is, what is
I think
judicial
we are
review?
running out of the time. We are
Yes,
running
sir.
out of the time now.
Okay, sir. Okay.
Yes, sir.
Please
can
summarize your question. Yes.
Question
We'll
is
reply
now.
the other questions.
Okay, sir. Okay.
Good.
Okay, Madhuri,
Yes.
you can start concluding session.
Okay, sir. Okay. Thank you so much for your valuable guidance in both the languages, Marathi and English. It will definitely be very fruitful to all our attendees. Now, I would like to invite Dr. Amol Chauhan sir to give his concluding remarks. He is Assistant Professor in MP Law College, Aurangabad. Over to you, sir.
Yes, good afternoon to all. First of all, I am thankful to Professor Morey sir for his wonderful lecture on the constitution law. At the end of the conclusion of this lecture, I would like add something which is already covered by Morey sir. As we say that the Constitution of India is a fundamental and the supreme law of land. It means that the other laws are within the ambit and the framework of the Constitution of India. Whenever any provisions of law go beyond that particular fundamental principles or the basic structure of Constitution, then that law should be declared as a null and void. Secondly, when we discuss that the concept in the preamble which start with the letter that is we, which denotes the ultimate sovereign of the people of India. It means that we, the people of India who rule over the democratic country like as India, which provides the rights to every individual irrespective of any kind of distinctions between the peoples. Secondly, when we talk about the constitution, or the constitution is a fundamental law of the land, it means that when we talk about the constitution is a father of all the laws, then the one questions may arise in our mind: what about those laws which were introduced before the Constitution of India, that is before 26 January 1950? Now, so far the Constitution of India is concerned, where the Article 13 says that the law which are abrogate the provisions of the fundamental principles or the basic structure of Constitution of India, that law should be declared as a null and void. It means that the law which is declared prior to the introduction of Constitution, but which abrogate the fundamental principles or the basic structure of Constitution, then that law should be declared as a null and void by the Constitution. They see the unique feature of our Constitution of India. Secondly, the Constitution maker provides the schemes, duties, liabilities, privileges for all the people, irrespective of any kind of discrimination, which is already discussed by Morey sir, which is reflected under the part 3rd of Constitution of India, that is called as fundamental rights. Secondly, the Constitution of India is a combination of various philosophies and the reasonings developed through the various landmark decisions by the Supreme Court of India, as rightly pointed by Morey sir, that the Constitution of India was amended several times with view and with the aim to provide the better protections to each and every individual, irrespective of any kind of distinctions and discrimination among the people. Now, so far the Constitution of India is concerned, Constitution is a basic document which set up on the democratic principles of your country. And when we discuss about the basic structures or the basic principle of Constitution, at the end of this conclusion, I would like to mention that the Constitution is a garland where the diamonds, not the diamonds what we are thinking, diamonds in the form of rights, duties, liabilities, fraternity, liberty, and so on, and so on. These all diamonds are thread in the forms of rights, duties, and liabilities for every person, irrespective of any kind of discrimination based on age, sex, color, caste, religion, etc. It means that this particular Constitution of India provides the fundamental principles or the rights which are very essentials and fruitful for the overall development of all the human beings. With these concluding words, I thank you to all the participants who are listening this particular lecture. Thank you very much. Over to Madhuri.
Thank you so much, sir. Actually, there was some mobile problem from my side, so I really apologize for that. Now, it's my duty to express a vote of thanks. I would like to express my deep gratitude towards our today's guest, Professor Shrikishan Morey sir, for his inspiring and positive guidance. I also thank Dr. Amol Chauhan sir for his concluding remarks and Dr. Vyas sir for their valuable presence. At last, I thank all teaching and non-teaching staff of MP Law College to make this session successful. I thank all attendees for their patiently listening in this webinar. Tomorrow means on 19 July 2020, Senior Advocate V.D. Sabkal sir and Dr. Aparna Kotapalle ma'am both will be dealing with the family law topic together. I kindly appeal all the attendees to attend this webinar. Till then, take care and stay safe. Thank you so much. Thank you so much, sir. Vyas sir?
Thank you.
Thank you, sir. Vyas sir, shall we end the session? Vyas sir? Morey sir?
Yes.
Yes, yes.
The weather is leaving.
Sir, hello.
Yes, yes.